Morning's calendar, and these are all just sort of leftover arguments from last September when we were sort of derailed by the hurricane, so appreciate your patience. Leading off, 20-10977 U.S. v. Singletary. Mr. Bell, you're going to bat lead off today, so come on up. Morning.
My name is Robert Bell, and I represent Mr. Singletary in this appeal that really presents one issue but two facets of the same issue before this court. But to summarize this thing, I don't think I'm going to be real long here this morning, but in connection with today's argument, there are three things that are true, I believe. Mr. Singletary was charged, pled guilty, and convicted to possessing firearms in the aid of drug trafficking offenses. He and the complaint, the indictment, the PSR, the factual resume abundantly make that clear. He procured firearms for drug traffickers. That's what he was charged with, 924C, not 922G as a prohibited person. That's definitively true. B5 of 2K 2.1 was applied to him because he engaged in the trafficking of two or more firearms in connection with events and people that he knew was unlawful. The record makes clear it was because he gave them to drug distributors, people in the narcotics business. The third point that is also true is that under B6B, his sentence again was enhanced for the exact same conduct, for giving guns, procuring guns for people involved in the drug business, which was the underlying charge that he pled guilty to, was convicted of. It is our contention that the enhancement under B6B was improper for two reasons, and is based on this court's precedent. First of all, that behavior and that conduct can't be based upon the underlying offense of conviction. I don't like to read to the court, but this is just cuts to the chase. In Guzman, unpublished opinion that was later ratified by Velasquez, this court said, based upon the amendment to the commentary, this court concluded in Juarez that by adding the word the Sentencing Commission no longer intends to exclude all explosive or firearm possession or trafficking offenses from the definition of another felony offense, which is under B6B. Instead, it now intends to exclude only the possession of trafficking offenses that serve as the defendant's crime of conviction. Bingo. That's what occurred here. Now, the court went on to say, in this case, it doesn't apply because he was charged with making false statements to a federally licensed arms dealer. It was separate and distinct from the enhancement, the conduct. Here, the enhancement was based on the exact same conduct as the underlying offense of conviction. Now, there's some debate by the government on whether error was preserved. That really relates to the double counting of applying both B5 and B6B. On this, they acknowledge that the error was preserved, and it's clear under Guzman, under Juarez, under Velasquez, that the underlying offense of conviction conduct can't be the same thing as conduct used to enhance the sentence, which it was here. On the double counting, the same court says, we agree that Juarez did not decide the issue before us. We're not deciding whether illegal smuggling of firearms constitutes another felony offense, as we were in Juarez. Rather, we must decide whether Note 13D expressly prohibits the application of a 2K21B5 trafficking enhancement in combination with a 2K2.1B6, another felony offense enhancement, when both these enhancements are based on the same trafficking offenses. And the court said you can't do that. You can't do them both. Now, the government says, hey, listen, he was a trafficking offense, and this other offense was drug distribution and drug narcotics. But again, this is not a 922 offense. This is a 924C offense. It's all tied together. He wasn't charged with just trafficking firearms. He wasn't charged with being a prohibited person. He was charged with trafficking firearms, being possession of firearms for the sole purpose of aiding drug traffickers. Thus, to enhance his sentence under both B5 and B6B is impermissible double counting, as this court found in the Guzman opinion. And so for those reasons, we think that his sentence was improper. Now, even if on the double counting we go to the the plain error standard.
Acknowledge those are two separate complaints about the enhancements. The 6B6 was enhanced, you say, based on the underlying offense of conviction. That's sort of point one. And then point two is 6B6 enhancement double counts the B5.
Yes, because it involves the exact same conduct.
Right, so those are, I guess analytically, those are two separate complaints about the enhancement.
Yes,
okay.
That is correct, Your Honor. Now, even under the plain error standard, based upon on the double counting that B5 and B6B are double counting, error is clear here. First of all, the court's decision is at odds with this court's decision. The district court's decision is at odds with this court's decision in Guzman, and thus it was plain error and obviously affected his substantive rights. He received a guideline range of a total offense level of 31 and a guideline range of 108 to 135. Without the 4-level enhancement in B6B, it would have been 70 to 87. The court expressed an interest and a desire and did so to sentence Mr. Singletary at the low end of the guideline range. It did so, and so that's one, it's clear that but for the application of this enhancement, the court felt it was doing what was legally right, that without that, his sentence would have been 70 to 87 months and potentially 70 months. So for that reason, there is a harmful error. It did affect his substantive rights, and for these reasons, we ask that the decision of the lower court be reversed and this court case be remanded.
Why isn't this case like Luna, where the enhancements are penalizing different offense characteristics and don't double count the same conduct?
I don't think they are different characteristics. I think it's the exact same conduct. And that is, and it's exact same policy reasons. We don't want to do what? To put guns in the hands of narcotics distributors, because we know that's dangerous. It's dangerous for law enforcement. It's dangerous for a lot of people. But that's the exact same reason that both enhancements were applied. So the exact same factual background, he's being enhanced by 8 levels for the exact same conduct under B5 and B6. But even then, we don't have to get there because, again, it can't be the same conduct that underscores the offense of conviction, which here, since he was charged under 924C, it definitely is. That makes it improper. He is already being sentenced for violating 924C. We don't need to add on to him and pile on to him because he violated 924C. We know he violated 924C. He admitted it. The record is replete with evidence of that, but it doesn't mean that his sentence should be enhanced under B6B.
Okay,
Thank you.
appreciate it. You've reserved some rebuttal time,
I'm good.
which you may or may not use. Okay. All right, now we'll hear from counsel for the government. I take it you see things differently.
I think so, Your Honor. May it please the court, Ryan Niedermair for the United States. This court should affirm Singletary's sentence because the district court properly applied a 4-level enhancement under B6B in connection to Singletary's conviction and conduct. In his reply brief, Singletary forfeited any argument that his enhancement under B6 was impermissible double counting because it allegedly involved the same conduct supporting his enhancement under B5. As such, the only question left for this court to answer is whether Singletary's conspiracy conviction is a different felony offense than that of his co-defendant's drug dealing.
So you're saying your view is, I mean, counsel opposite, I think, wisely conceded that the two complaints about the application of the B6B enhancement are really distinct analytical arguments. One being you enhance based on the underlying offense of conviction, and then the second being the double counting. And you're saying the double counting has been forfeited, so we don't even have to address it under plain error?
Yes, Your Honor. On page 3 of the defendant's reply brief, the defendant makes clear that he is making a single objection to the court sentence, and that is that his co-defendant's drug dealing was not another felony offense under B6B.
Okay, so we'll see what he says about that. You were, just to get you back to the underlying offense of conviction, if you could help me to break out what he was convicted under. Counsel on the other side says 924C, and explain to me why that offense is not the same offense as he's being enhanced for another felony offense. That was poorly worded, but you understand what I mean.
Yes, Your Honor. With all due respect to Mr. Singletary, he was not convicted under 924C. He was convicted under 924O, which is a conspiracy to possess a firearm in relation to a drug trafficking crime. And in fact, if he was convicted under 924C, we wouldn't even be here because he would not be subject to guidelines under 2K 2.1. He'd be subject to guidelines under 2K 2.4. As such, Mr. Singletary's offense of conviction, a conspiracy conviction, is a distinct offense that is completely separate from the other felony offense that was used to enhance his sentence under B6. That other felony offense was his co-defendant's drug dealing. And you can see that the PSR applied the same reasoning at 285 in the record. The PSR recognized that the enhancement applied because Mr. Singletary transferred firearms with the knowledge or intent that they would be used in connection with his co-conspirator's drug activity. And because his co-defendant's drug dealing is a distinct offense from Singletary's underlying offense, which was a conspiracy to possess a firearm, not possession of a firearm, not firearm trafficking, this enhancement is proper. And the only way to take account for the full breadth of Singletary's conduct, that is, his trafficking firearms to people that were prohibited people, but then also his transferring firearms to people he knew were going to use them in the drug trade, the full breadth of his conduct can only be accounted for by applying B6B.
Was there overlapping conduct between the 924O conspiracy and the other felony offense that he's being enhanced for under B6B?
No, Your Honor.
Okay. Explain that to me.
Mr. Singletary was not a drug dealer. He was a straw purchaser for a drug ring. His own conduct did not involve drug dealing. So 924O means that he just entered into an agreement with others to possess firearms in furtherance of drug trafficking. And it doesn't mean that it's a firearm trafficking conviction. As a matter of fact, Broderick Jones, one of the co-defendants in this case, and you can see in the record at 402, did not receive an enhancement for firearm trafficking. So that right there shows that this is not a firearm trafficking offense. And while Mr. Singletary himself was not involved with the drug trade, his co-conspirators, who he transferred firearms to, were. And he knew that they were, and he knew that he was going to give them guns to help them with their drug dealing. And that is why the B6 enhancement was proper. In sum, Your Honors, because Mr. Singletary's conviction was completely distinct from his co-defendant's drug dealing, the district court properly enhanced his sentence under B6B. And I know that I've been incredibly short, but if there's no other questions from the court, I would gladly cede the rest of my time.
I noticed, well, so I guess I was going to ask about the Fugate decision from the Sixth Circuit that's a split decision, but that's about a double counting issue, isn't it?
It is, Your Honor, but I'd be happy to answer any questions.
If we got to the double counting issue for whatever reason, do we have to take sides in the dispute over how B5 and B6B interact? The Judge Sutton disagrees with the other two judges about how those two things interact. Is this a case that would require us to take sides?
Not at all, Your Honor. And that's because even if this court were to address the double counting issue, there was no overlapping conduct here. Actually, you know what? I'm sorry, Your Honor. Let me rephrase. The guidelines allow for the counting that happened here. This court has recognized in Guzman and Velasquez that applications note 13 to B5 and application note 14 to B6, when read together, explicitly allow for a defendant to be enhanced for trafficking firearms and then enhanced if he transferred one of those firearms in connection with another felony offense. Now, the key is that that other felony offense can't be another firearm possession or trafficking offense. And in the Sixth Circuit decision, Your Honor, the problem there was that the other felony offense was a 922J distributing stolen firearms. It was another firearm offense. Here, that's not the case. This is
Drug trafficking.
Yes, Your Honor, exactly.
I see. So that's, we wouldn't, if we got into that, we wouldn't have to take a position in your view on the dispute.
No, Your Honor. And that's why this case is different than every case that Mr. Singletary cites. This is not a case where the other felony offense was a firearm trafficking offense.
Okay.
Okay. Anything else?
No, Your Honor.
All right, we appreciate it.
Thank you.
Mr. Bell, you have some rebuttal time if you want to step right up.
And I'm not sure the argument that first began that there was some type of waiver in our reply brief. The reply brief solely deals with whether error was preserved. Waiver, as we all know, is an intentional relinquishment of a known right. If I recall my law school days correctly, I don't think we waived anything by discussing what is a proper standard of review in our reply brief.
So you're saying you have not forfeited, you have not abandoned, let's say, the issue of whether there was double counting under B6B and B5?
No.
We should still reach that,
Yeah.
possibly under a plain error
I
standard?
agree it's a closer call on the standard of review.
Okay.
Okay, I agree. And I think the government concedes that on whether it formed the basis of the same conduct as the offense of conviction, the error is preserved there.
I understand.
And here, I mean, the facts really aren't in dispute, so I think it would be really a de novo review of the application of the guidelines to an undisputed fact scenario. So I don't think that we have waived anything. And I disagree with counsel in the attempt to distinguish these other cases. And I think that Guzman and Velasquez and Juarez are all on point. And again, we don't have to reach the double counting issue. The court doesn't want to. You know, the government seems to suggest that Mr. Singletary was not involved in drug offenses.
Well, I think what the government was saying was the principal argument, as I understand it, was Mr. Singletary was convicted under 924-0 for conspiracy to possess a firearm in connection with drug trafficking, and that is a different offense from the other offense under B6B that he's being enhanced for. So what's your response to that?
I disagree. First of all, 924-0, yes, because in violation of 924-C. So, I mean, the indictment is clear. The 924-0 is the conspiracy part of 924-C. And it's also important to remember that the people he sold the guns to are his co-defendants, charging the exact same offense, right? He was involved in I imagine it's the government's position that this, you know, under the armed, whatever, the enhancement provision, I forget, under the guidelines, this would constitute as a drug trafficking offense. It is, because that's what he was charged with.
Drug trafficking, I'm just looking at B6B that says you get enhanced if you transferred any firearm with knowledge, intent or reason to believe that it would be used, if the firearm, I guess, would be used or possessed in connection with another felony offense. So I think what the government's saying, and I may get this wrong, but is that he's been convicted under conspiracy to possess a firearm in connection with drug trafficking. That is sort of the overarching offense. And then another felony offense, I guess, would be drug trafficking itself.
I don't think that the statute intends to parse it like that, to somehow distinguish between conspiracy to do something and to actually do something. The same substantive facts are at issue, and he's being punished, his sentence is being enhanced for the same conduct.
I mean, what
And again,
I need to look at application note 14 so I can understand what the thing means.
good luck.
Another felony offense? Well, no, I mean, I like to read the application.
I understand, and I do too, because they're
When I need to go to sleep at night.
yeah, they can be helpful.
It says another felony offense means any federal, state, or local offense other than the explosive or firearms possession or trafficking offense.
Yes. What was he charged with? Trafficking of firearms to aid drug distributors. So, all right,
Well, we'll have to think about that.
good. Thank you very much, Your Honor.
Very welcome. Thank you both, counsel. Mr. Bell, I think you were CJA appointed. Is that correct?
I am, Your Honor.
Court appreciates it. Thank you very much.
I appreciate the opportunity to be before you today. I'm sad, though, today that I heard that Meatloaf died, and that's
that right?
That's bad news, so, yeah.